Good morning and welcome. As people are settling in and enjoying their breakfast, I just wanted to take a few minutes before the program started to welcome everyone to our Hull and Hull breakfast. It is our inaugural 2011 breakfast, and we're excited about this year's series. The committee who sits together to organize these breakfasts are always trying to think of different topics that touch all of the areas of practice of an estates and trusts practice, and we're really excited about the programs today, but over the year we've come up with a couple of new topic areas that we're hoping will be well received. I'm Ian Hull, and I apologize for those. I've taken a little bit of abuse for missing the last breakfast. It wasn't that I slept in, but I was out of town on a trial, so I'm glad to be here today. I just wanted to take a minute before the program starts just to introduce some of the people in our firm for those of you who might have dealt with them or have heard them or have just seen them by email and so forth. First of all, not in any particular order because I had to have this written down for me because I knew I'd forget someone. We'll start with Susanna Popovic-Montag, who's our managing partner and a regular speaker in the series, of course. A new associate, Sarah Halstead, who's here over here. Julia Evans, who's also joined us fairly recently. Our articling student, Genevieve Girde, right here. We've got some of our clerks, our law clerks here, Christine Mercer, who, if you deal with me at all, she's the one that kind of holds the whole ship together, I got to tell you. Heather McGinnis does our state accounting work and our state planning work. Elizabeth Sonderskov, another clerk, Heather Franciszkowski. Heather's going to kill me because I say it wrong every time, but Nadia Harasimowicz, got that one well done. Paul Trudell, David Smith, and David and Paul, partners of ours, and then Hugh McKenzie is a law clerk as well. Hugh's over here. So thank you, and puts a name and a face together if you are dealing with anyone on any matters. The last point I just want to say from an introductory standpoint is that for those of you who care, it is this program has been, after careful negotiations by my partner Craig Vanderzee, CPD or Law Society approved for 30 minutes of the professional development requirements, which we now have to do for a minimum of 3 hours. Frank Felkai has offered to negotiate for us for the next one to try to get it up to an hour, but I fear that would be a bit of a dry program if we focused only on that issue the whole hour, but we'll see. You got your points for 30 minutes anyway this year. We're pleased to start the program today with Craig Vanderzee, my partner, and he's going to talk about, I'm forgetting it, I don't have the agenda in front of me, but he'll tell us.
Good morning, everyone, and a belated Happy New Year to everyone, and thank you for joining us this morning. My topic, because I did check, is a review of recent trust case law. And I would invite you to read the paper because there are going to be a number of cases that I don't cover this morning that are in the paper that I thought were of interest. And the paper in general covers cases that touch upon issues dealing with foreign trusts and trustees, that is, foreign trustees, the removal of estate trustees, constructive trust costs, and summary judgment. So again, it's not meant to canvass all of those areas of law, but to touch upon some cases within the last couple of years that I think, and I hope that you will think, are of interest to us all. So two of them, and dealing with the time this morning, I will try and deal with them in a cursory fashion. Are the foreign trust and trustee cases. And the two cases that I just wanted to mention were two cases that have been well publicized and well commented on, and those are the cases of Guerin Family Trust in the Queen and Antolin the Queen. And those cases were decided in 2009. Both cases deal with tax court decisions, as you may well know, and dealing with the residency of the trust itself. Now, both of those cases, to get to the chase, were appealed to the tax court, and then subsequently appealed to the Federal Court of Appeal. The appeals were just recently heard. and I'll touch upon them in a moment. Quickly with the Guerin case, and sorry, before I do, if you're interested in some other commentaries, Ed Esposto has a whimsical commentary on both of the cases before they were heard by the appeal court. And his article can be found in the December 2009 edition of Deadbeat, and it's called Pyramids and the Wizard of Oz, Guerin and Antle. And then Susanna Popovic-Montag has an article herself entitled Canadian Taxpayers Beware, Foreign Trusts May No Longer Be the Same. And so those are two articles that I would encourage you to read. Quickly with the Guerin case, this is one where I think most estate planners were quite surprised by the result. This was one where a Canadian taxpayer owned shares of a company and carried out a reorganization way back in 1998. And it was very similar to an estate freeze. And a trust was settled by a resident of the Caribbean island of St. Vincent. There were two trusts that were settled. And then the reorganization occurred where the trust subscribed to shares in a newly incorporated company, and that company in turn had shares in the original company that I mentioned, which was quite a large enterprise. The company, which dealt with automotive parts and the sale of them, sold 2 years later, and there were capital gains of $450 million. And so obviously this caught the attention of the minister. The minister assessed the capital gains, saying that the exemptions that might ordinarily apply in the treaties between the two countries did not apply in this situation because of the residence of the trust. Wasn't, as we might have thought, in Barbados, but rather in Canada. And the key to this case, and which draws the interest, is that the court did not, this is the tax court, did not apply the decision of Dill and Perlman, which stands for the proposition that the trust is resident in the jurisdiction where the trustee resides. To the contrary, what the court did was decide that they're going to apply the test that is applied in the case of where the control and management is for a corporation. And that was very different in these particular circumstances. In the end, the Tax Court of Canada said, no, we're agreeing with the assessment and we are dismissing the appeal. The appeal in Guerin isn't commented on in my paper because that decision was just released in December of 2010. And I would urge you to read it. The Federal Court of Appeal found that indeed the lower court judge didn't get it wrong and dismissed the appeal. So that will be providing for interesting consequences down the road for those involved in estate planning and dealing with trustees in foreign jurisdictions and how the trusts are set up and how the assets are organized, knowing that this decision is out there. It'll be interesting to see whether it's appealed to the Supreme Court of Canada. In the Antle decision, this is often seen in the same light as being a case dealing with the residency of the trust. But it really isn't. It's dealing with the certainty of the trust and whether the trust was actually created. In this case, it dealt with the legality of a capital, what they've termed a capital property step-up strategy, whereby an accumulated capital property, a gain in capital property, shares in a company, were shifted from a husband to our Barbados spousal trust. And if you read the facts of the case, it became very clear to the court that there was no certainty of intention, there was no certainty of subject matter, and of course to have a trust we need the third certainty of there being a certainty of object of the trust, but in this case the court didn't need to focus on it because it already had 2 of the 3 strikes there. And in this case, again, it was appealed to the Federal Court of Appeal, and that court also in October of 2010 dismissed the appeal. So I think that that's a bird of a different feather, if I can coin that phrase, in the sense that this was looked at by the Federal Court of Appeal as a sham. The lower court found that there was absolutely no intention to create the trust, but did not quite step out so far and determine that it was a sham. Federal Court of Appeal said, no, on the basis of the fact findings you have found, this is a sham. So from a practice management standpoint, it is key in dealing with clients to really determine where the true intention of the reorganization is going. It may well look like on paper that it is not a sham, but based on the facts in the Antle case, the trust document wasn't executed on the day intended. The shares were never transferred to the actual trustee. So as a lawyer dealing with an estate plan, you want to be very careful from the very initial meeting with the client to determine who is the client, what is the ultimate goal, how are we going to get there, what is the prevailing case law, and then as you're working through the case, determine, is this a sham? Is this something that can be supported by case law? Is this something that that I, as a lawyer, can stand behind, and is there going to be ethical considerations at the end of the day in this kind of situation? So something that might start out as something with an intention to actually come to a valid trust, in the means of executing the trust may well indeed not be, and may in turn turn into a sham. And if that is the case, then you run into a problem that they ran into in Antle, and the client is facing not only taxes, but penalties and interest, and perhaps ultimately other consequences as well that might affect the business or the personal finances of that individual. And so you want to be wary of discussing that with the client as soon as possible when you see the situation unfolding. Now, the other topic that I wanted to touch upon at this time is the removal of an estate trustee. And in the case of Gonder and Gonder, which was a case decided in 2010, and this is found on page 11 of my paper, this is an unfortunate situation for the estate trustees, but it bears paying attention to the facts of the case because it can be a common situation with modest estates. Here we had a situation where the estate trustees wanted to remove themselves, not because of conduct that was alleged negligent or otherwise as against them, but because they found themselves in a situation where they couldn't deal with the assets of the estate. And in trying to deal with the assets of the estate, they were going personally into debt. And they found themselves in a conflict of interest because they were not only, as I'll mention briefly next, a beneficiary of the estate, they were an estate trustee and now a creditor. And how do you deal with all of those hats? In short, a sibling passes away, and the sibling leaves to her mother a life interest in her estate, and then there is a sister and a brother of the deceased. There is a modestly valued house, and then there's about $25,000. So on the face of it, if someone was coming into the office, it looks like, you know, you sell the house, and then you'll have enough money to do a distribution at the end, take care of the debts, and it seems like it's a pretty safe situation. What happened here, though, is that the brother, once they were appointed as the estate trustees, sued the estate, saying that there was a constructive trust because he had transferred the house to mother 18 so years ago, and that there was a trust for him and his children with the house. He puts a certificate of pending litigation on the property. No one's living in it. You can't sell it. You've got the expenses of it. And by the way, they found out that the CRA had a $32,000 lien on the property. So because of the litigation, they forked out $40,000 of their own money. Now they're looking at a situation saying, we can't bleed any further personally. We've got to get out. Well, this is a situation that can perhaps be dealt with once the client comes right into your door, and to say, okay, what do we know about the assets? What do we know about the debts? What do we know about the players? What do we know about the brother? Is anybody going to make any claims? Do we see this coming? Because if that's the case, then you certainly need to give advice to your client as to whether they want to accept the appointment. Maybe it's a situation where if it's going to be in financial hardship to them, they don't want to be putting themselves in that situation. Maybe from the get-go, you've got to bring a motion for directions as to how you're going to deal with this estate and how you're going to be able to sell it. And when do you bring that motion? Do you wait a year into the litigation, or do you, upon the CPL, do you make a motion to the court to sell the property, put the funds into a bank account so at least the bleeding stops on all the expenses with the property? So from a practice management standpoint, it appears like it would be a fine situation, but you have to delve into at the very beginning of the day, what are you dealing with, and what's behind the rock you haven't unturned yet? And those are the questions that I ask when this kind of case comes in. From a legal standpoint, at the lower court level, the judge said, you brought your motion pursuant to Section 37 of the Trustee Act, and that act allows me, the judge said, to allow you off. That is to allow, to permit you to be removed without providing for a succeeding trustee. And that was the key to this case, because who was going to take it over? Who wants to come on in a situation where there's no liquidity, you've got a house with expenses, there's a CPL on it, and the only thing you're really looking at in the near future is legal expenses? And so the PGT, I believe, in this case, was asked or invited if they would like to become involved, and the PGT graciously denied that they were involved in a case and it could be worked out with the family. And again, there was no one under disability here. It was just a question of a difficult estate administration. So the lower court said, yes, you're off. The Court of Appeal said, no. It's not that you were wrong and thinking that they should be removed, because they've been put in a difficult situation. These are good people. They tried their best, but you can't just leave the estate unadministered. What was interesting, though, is the Court of Appeal in turn said, wait a second. I can make arrangements, or that is, someone can make arrangements, not necessarily by appointing a succeeding trustee, but making some sort of orderly transition by removing one party and allowing for the estate still to be administered. In this particular case, the Court of Appeal didn't necessarily espouse on that, because they sent it back down to the lower court to deal with it and to deal with motions. But the Court of Appeal, when you read the case, took the time to think about different ways that it could be resolved. But you could think of a scenario where if this came up and it was just dealing with debts and liquidity, where you could freeze the estate. And there could be someone who's appointed on an interim basis as a succeeding trustee. So you can be cautious, but you can also be innovative here if you have to have your client removed. Of course, in this situation, you could try to have a financial institution appointed, but then it's also the financial institution which is found in a difficult spot if they're looking at an estate where perhaps even their compensation might not be paid if the house is rightfully the son's, because then who is going to be paying those legal costs for administering the balance of the estate? So from a practice management standpoint, it's critical in these cases, which appear on the face of them to be run-of-the-mill in a modest situation, but you have to delve deeper from the beginning and warn your clients as estate trustees of the difficulties in getting removed if there is no obvious choice to come on board in a difficult circumstance. I'd also like to touch upon the constructive trust case of Vidichak and Gary Antonou. I mispronounced that. That's found at page 15 of my case, of my paper, and that is a 2009 case. And this deals with a joint asset bank account. So on the face of it, PCOR applies, and everyone would think that the presumption applies, and there's nothing really to talk about this case. This was a situation where there was a mother who passed away and 3 kids. She had a joint bank account with one of the children, and she also had GICs jointly held with the other 2 children. Interestingly, the court found that the presumption applied in the case of the bank account because of the evidence that was before the court, but then turned to the GIC and said, no, GIC's fine, it's jointly held, and didn't seem to apply the presumption in the same way that it did with the joint bank account, relying on the fact that joint bank accounts, according to the judge in this case, are typically and well known to be for the purpose of helping the elder parent with the administration of their estate in an informal way. Whereas a GIC is a certain animal, it's a certain document, the names are on it, and it was clear in the intention. I'm not so sure that I would have drawn the distinction in the same way that the judge did in this particular case. But it's an interesting case to watch out for because of the treatment and the difference in the treatment, arguably, between the GIC and the joint bank account. So it's one of those, even from a practice standpoint, when you're dealing with your client and they want to set up joint assets, to be wary of how the court might down the road look at these situations, and ensuring that the true intention of the client, if it's the deceased in this case before she passed away, is actually conveying that interest in the way that they want to, and so that it's equal across the board if that's what their real intention was, in this case, to share a joint asset in form of a bank account with one and a GIC with 2 others. Lastly, I would like to touch upon summary judgment. The summary judgment rules, and this can be found on page 18 of my paper, The summary judgment rules underwent, as we know, what some would characterize as a substantial change in 2010. There is a case that I've cited on page 19. It's titled Healy and Lake Ridge Health Corporation, and it's a case in 2010 decided under the new rules. It's not an estate or trust case, but I included it in the paper for what Justice Perel says as to the handling of the new rules. Under the prior rules, it was always conventionally thought and followed, it could be submitted, that you had to have a genuine issue for trial. And once you prove that, then your summary judgment was to fail. And in so doing so, you weren't allowed to weigh evidence or evaluate credibility or draw inferences from the evidence, or even have the ability to call a witness in front of you as a judge to hear oral evidence. Well, that changed under the new rules. And Justice Perel, in the second paragraph of my paper on page 19, quotes that and indicates that under these new rules, all those factors come into play. And so as such, when we're dealing with estate and trust cases where we know that summary judgment was available under the old rule, we want to consider from the beginning, from the moment I do, when the client comes through the door, as to how am I going to proceed. And if it's a frivolous case, then in the situation, you might want to consider a summary judgment motion. And in now preparing for a summary judgment motion, you could possibly prepare for the fact that you might have viva voce evidence. You may have the ability of the judge to weigh the credibility of witnesses, whereas over a year ago that wasn't going to be the case. And so the manner of proceeding with a piece of litigation may be considered in a different light now because of the changes in the summary judgment rules. And it would seem that the intent behind that was to try and have the ability to get some of these cases before the court and decided in a more summary type of procedural fashion than in the past. And the ability to deal with these cases where they may be factually unsupported and an attempt by one of the beneficiaries to obtain more money or from someone who doesn't have an interest to try and obtain that, and perhaps by way of just bringing a claim in the hope that they'll be able to negotiate a settlement. This summary judgment set of rules may be a vehicle through which we as estate and trust practitioners might be able to derail that type of train closer to the beginning of the litigation. And so with that, I'm happy to take any questions at the end of the session, and thank you again for coming.
Thank you, Craig. Sorry, not to emphasize the moving of the microphone. Couldn't help myself. Well, that was terrific. Our next speaker, Rick Bikram, associate at the law firm, is part of our guardianship team. We enjoy this area of the practice a great deal. It's obviously a big part of an estates and trust practice for all of us. And Liz Saunders-Gov and Rick and I sort of work closely together on dealing with different components of just the classic getting a guardianship order, appointing someone where they haven't done what they should have done, and that is got a power of attorney done, and also from the personal injury perspective, doing reports and analysis of what it's going to cost a guardianship over a period of a lifetime. And we've really enjoyed this work over the past 10 years. It's grown a lot. I mean, obviously the Substitute Decisions Act refocused a lot of people's attention to it, but one of the unique aspects of guardianships we find is this whole idea of just how expensive, and the personal injury bar now comes to us and says, we need you to do an opinion on what's it going to cost to have this injured person looked after by a guardian for a lifetime. And the many, many thousands of dollars and the intricacies of what that's going to involve, say, over a 40-year or 50-year period for maybe a younger injured person reminds us of the obligation and the importance of just getting the power of attorney document organized and in our clients' hands in a timely way, because not just getting a guardianship order, which can be expensive, having the document makes it gives a chance for us to have a discussion with our clients to say, okay, now it's not just taking over your affairs. This is a big undertaking, and for example, it can cost many, many thousands of dollars over a lifetime to do this. You're well paid, and you're not well paid, truthfully, but you're paid, and it's worth it to pay an individual for it. But the financial analysis has been an interesting eye-opener for us, and it continues to be a big part of the bar we're struggling with. So what we thought we'd do today is have Rick speak a little bit about what the guardianship process is about, what's required, to give us a little bit of an understanding of, to warn our clients, get a power of attorney. You want to avoid ever seeing Hull and Hull, because this is a mess, and it's expensive, it's time-consuming, and it brings in the Office of the Public Guardian and Trustee and the Office of the Children's Lawyer at a level that you might not want if you can avoid it. So looking forward to Rick's comments on guardianships.
Thank you, Ian. As Ian indicated, today I'm going to be speaking about guardianships. Before I start, I just want to set out that there are classes in law schools and universities that spend a whole course on the issue of guardianships, and my 15-minute discussion in no way intends to be a substitute for that class. At the very basic, what is a guardianship, or who is a person who is a guardian? What's the textbook definition? And the textbook definition of a guardianship is a person who has been appointed by a judge to take care of an incapable person. The Substitute Decision Act is the governing statute which sets out or plans for mental incapacity and substitute decision-making in incapable adults. The first step in any guardianship is a finding by a court that someone is incapable. When we apply to the court, when a proposed guardian applies to the court, what they're asking the court to do is pretty much three things. First thing they're asking the court to do is, hey, judge, please take away the right of this allegedly incapable person from making a decision because he's mentally incapable of making that decision. Number two, pick me exclusively to make that decision. Number three, trust me, I'll do it. Before I start any guardianship applications, those are the first three principles that I run through my mind. And that helps me prepare my application materials. Even going to a guardianship hearing, when I'm in front of a judge, those three principles are the first things I'm thinking about so that I can tell my story a lot better to the judge. The Substitute Decision Act, Section 6 of the Substitute Decision Act, sets out the threshold test in determining whether or not a person is incapable of managing property. And Section 6 of the SDA says that a person is incapable of managing property if the person is unable to understand information that is relevant to making a decision in the management of that person's property, or, alternatively, the person is unable to appreciate the reasonably foreseeable consequences of making a decision or the lack of making a decision. And essentially what that means is if a person has a stock in company A and there's information coming to that person that the stock is tanking, and the person decides to hold that stock as it dropped from $100 to a cent, that may be an indication that that person was unable to understand information relevant in making a decision towards his or her property. Section 45 of the SDA sets out the threshold test in determining whether or not a person is capable of managing his or her personal care. And under the SDA, Section 45 says a person is incapable of personal care if the person, again, is unable to understand information that is relevant to making a decision concerning his or her own health, nutrition, shelter, clothing, hygiene, or safety, or is not able, again, to appreciate the reasonably foreseeable consequences of making a decision or the lack of a decision. One of the themes that are very common in guardianship applications is incapacity. Incapacity is a must. In a guardianship hearing, there is a presumption of capacity, and that only makes sense because what a court is going to do is take away the rights of a person, and it's up to the applicant to demonstrate to the court that that person is incapable of making a decision. That goes to the second element. The applicant has to demonstrate with clear evidence that the proposed person who's incapable is actually, in fact, incapable either A, to manage property, or B, to handle his personal care, his or her personal care. That type of evidence that we look at is what I refer to as opinion evidence. We have capacity assessors who are designated under the Substitute Decision Act, and they ordinarily conduct what we call capacity assessments. And they conduct capacity assessments, again, with respect to the two branches, personal care and property. And what a court is also going to likely hear evidence of is that there are no least intrusive means of managing the incapable's property. For instance, there's a case in 2006, an Ontario case, and that case I'm referring to is Martin v. Barole. And in this case, a court held that a poisoned relationship between two joint attorneys was not enough for a judge to appoint someone as a guardian. Why is that the case? Because there is a wish by the incapable person that before he actually became incapable, it set out, I want these two to act as my attorney, to handle my affairs when I'm incapable. Essentially what the judge said here is, suck it up, princess. You guys are appointed under the attorney. I want you guys to work together, because that was his wish. Why do we need attorneys? Why do we need guardians? I'm starting to see a lot more literature on guardians, and I think that's because we're in an aging society. The baby boomers are aging, and in my eyes, what this signifies is the largest transfer of wealth in human history to date. That coupled with two principles. Number one, the cases of mind-robbing diseases, as I like to refer to it, dementia and Alzheimer's is on the rise. There's a paper that I refer to in my paper by the Alzheimer's Society. It's called The Rising Tide, and it's published by the Alzheimer's Society, and it states that this disease will more than double to 1.25 million people suffering from either dementia or Alzheimer's within the next 30 years. That coupled with the second principle, which is we altogether do not do a good job of planning for death. I'm certainly guilty of that. I probably spent more time planning for my weekend this weekend than I have planning for, I don't even have a will, and again, that's a perfect example of we don't plan.
You're not supposed to say that out loud.
And that is a reason why we're starting to see a lot of more literature with respect to guardianships. The Substitute Decisions Act also sets out the factors that a court will look at when considering the appointment of a guardian. Section 24 sets out the factors with respect to property. Section 57 sets out the factors with respect to person. Again, this is not an exhaustive list. This is just factors, three important factors that the court will consider. The first one is whether or not the proposed guardian is an attorney under a continuing power of attorney. Second factor is the incapable person's current wishes, if they can be ascertained. And the third factor is the closeness of the relationship of the applicant to the incapable person. Clearly, someone who is a parent or a child of the incapable person is likely to be considered more than a neighbor or a friend. But as we often see in estate litigation, that is obviously not always the case. A court will also look at the ability and suitability of a person to act as a guardian. And that's a very broad term, ability and suitability. What does it mean? Conflict of interest. Are there any conflicts of interest between the incapable person and the proposed applicant? Number two, what is the ability of the proposed applicant to post security? What I like to think of when I'm preparing my application materials and I'm looking at this requirement, I think to myself, what is the primary motivation here behind this guardianship application? Why is this person applying to be a guardian? Is it because of some sense of moral duty? Or is this person actually the best person or the proper guardian to be appointed as the guardian? Another subject that I would like to consider today is the duties of a guardian, and there's no way I'm going to be able to cover this, all of the duties. But one duty that I do want to focus on today is one of the most fundamental duties of a guardian, which is to keep your records. We often see way too much in this business, a guardian who's already been appointed they come to see us, and they ask us to help them prepare to pass accounts. We ask them, could we see your vouchers and receipts? And we often get, in response to that, a very, very blank look on their face. What is a voucher? What is a receipt? A voucher and receipt is exactly that. It's supporting documents that backs up the expenses spent on behalf of the incapable person. The SDA also considers other records that a guardian must maintain. And just to go through them very briefly, a list of all the assets acquired and disposed of on the incapable person's behalf, a list of all investments made on behalf of the incapable person, a list of all of the incapable person's liabilities, a list of all the compensation that the guardian takes, including the method of calculation. I think that's very important. If you're going to take compensation, which we often see, it's important to set out in your notes how it is that you calculated your compensation. With respect to personal care, decisions that are made with respect to the incapable person's safety, health care, shelter, medical reports, etc. Those are documents that we would like to see be considered. In terms of litigation, it's very rare to see a litigation over personal care, over the person's personal care. But then again, it's not impossible. It's not impractical. There's always the possibility of litigation, and it's always best to ensure that you have the proper documents and records to back up your decisions. Another duty of a guardian is that a guardian is required to act in the best interest of the incapable person. Section 66 sets out the guidelines that a guardian should consider when making a decision in the best interest of the incapable person. I think this is a cool provision in the statute, and the reason why is, as you go through the factors, I notice that they kind of go hand in hand with the criteria a court will consider when appointing a guardian. For instance, the values and beliefs that the guardian knows the person held when capable and believes the person would still act on if capable. Okay, values and beliefs of the incapable person. And that goes back to when I talked about criteria for considering a guardian. I talked about the closeness of the applicant to the incapable person. And it only makes sense that the applicant and the incapable person are close. That way that the applicant understands the values and beliefs of the incapable person. Also, a court will consider or a guardian should consider when making a decision in the best interest of the incapable person is the person's current wishes, if they can be ascertained, whether or not a decision is likely to improve the quality of life of the incapable person or prevent the quality of life from being deteriorated. Notice of application. I'm going to go into the preparation of application materials now. At the very least, your notice of application should be served upon the incapable person, a person appointed under a power of attorney for property or personal care, if there is a person, a trust company, the public guardian trustee or the children's lawyer, and immediate family members of the incapable person. Your affidavit supporting the application should set out three things. Number one, lifestyle. The incapable person liked to live in large houses, which is why I am proposing in my management plan that we purchase the following house. Number two, past practices of the incapable person. Charities the incapable person liked to donate to. He or she liked to donate to the Salvation Army, so I would like to continue that. Number three, activities, preferences, and relationships with family and friends. In your application materials, you will also have what is referred to as the management plan and the guardianship plan. The management plan focuses on the management of the incapable person's personal care, and the guardianship plan focuses on the incapable person's, the management plan focuses on the incapable person's property. The guardianship plan focuses on the person's personal care. And on that note, I notice my time is very scarce, so I will call it a day. Thank you so much.
Well, Rick, thank you so much. That's helpful and always, as I say, an interesting area of the practice. I am going to talk today a little bit about maybe some issues that are outside the box of what we see on an everyday basis, partially motivated by the fact that I'm always trying to shake things up in my own mind. And secondly, more importantly, was things like since the last sort of 3 or 4 months, we've seen some interesting articles in the media about some cases, some 2 very interesting cases out in British Columbia and a very interesting case from Supreme Court of Canada that highlighted my sort of thinking and my approach to talking about innovative claims. My paper is dealing with unjust enrichment claims because it really is I think, the frontier of some of this innovation. Over the holidays, I always like to read books that don't require too much of my attention, and so business-related books and things like that are always fun for me. I can kind of read parts of it and put it down and not really worry about what character was involved. But I read a book, and I actually ended up reading parts of it again because it was helpful for me to sort of look at from my client's perspective and what I'm doing every day. And the book's called Start With Why. And it's a book called, it's by Simon Sinek. We have on our webpage now a list of the books that we are sort of finding are interesting and helpful in our practice that are, they're not necessarily the standard. We're not looking, everyone knows, and go look for Williams on Wills or Theobald, some of the classics for the practice area. But interesting books that we're finding. And this book was really helpful for me because it seems to me that, as Rick was saying, and I thought it was a great example, why is the client applying for guardianship? Why is the client sitting across the table from me saying, I want to hire you after we have, made it perfectly clear that this is going to be expensive, entirely unpredictable, and you're probably better to spend your money at Niagara Casino? They still say press on. And it really is all about the why. The what is fundamental to why they're going to stay in the room and why we're going to continue our ongoing professional relationships with them. But it really is all about the why. And that helps me then come back to what are these innovative claims that are starting to move forward and why are they moving forward? And not that I really ever want to get inside of the heads of judges. It's a complex and dark world that I'll never be able to entirely figure out. But it is a world that they're people. And they're people who come with perspectives that the minute you think you understand, you're typically wrong. But when I was standing outside having our coffee, Scott Blair, the lawyer, not Scott Blair, the financial advisor. We have many Scott Blairs in the room, but Scott Blair, the lawyer, was nudging me and saying that if you don't talk about these BC cases that came out before Christmas, I'm going to ask you in the question period. And I thought that was great because it kind of did tie into what I wanted to talk about. There was 2 cases before Christmas where the British Columbia courts have essentially just completely nullified testamentary freedom in some respects. Now, as we always say with British Columbia, of course, they have a statute that says, the Wills Variation Act says you can not exclude kids, basically. Ontario doesn't go that far. I personally believe the Cummings decision did, but apparently no one else seems to believe that. No, there is some support for that, certainly strong in Ontario. But why that I thought was important was in Justice Wong, the first of the 2 British Columbia decisions that came out, really turned upside down this idea of how you treat your children, supported by a statute, and then the second decision flipped it around even more, on an even more substantial basis, the children that were written out of the will. Now, the second case was a little bit more money involved, and sometimes it's easier to move the eggshells around when you have many millions. But that being said, it really does highlight what is, I think, in some respects, probably not here yet in Ontario, but maybe. And the winds tend to blow across Canada and back with some impact. But the fact the courts in British Columbia keep repeating, and as I say, supported by statute, but keep repeating the concept, you can't act morally wrong. I think that's a theme that is still prevalent, and certainly in Ontario. I'm going to talk a little bit about where I've got, I can't just say that. I've got support for that theory, but I think it's growing in Ontario as well in some respects. That comes back to the why, and the why, I think everyone in this room understands that it really is the moral code and the moral ethics of our behavior do have a tremendous impact on how we are supposed to behave in the eyes of the courts and how we're supposed to behave in the eyes of society. The Brassard decision that came out in November by the Supreme Court of Canada has taken us another step as well, innovatively, all within what I'm going to talk about in a minute. David Friedman's article, he's professor at Queen's, all within a principled approach. This isn't just grabbing stuff out of the sky. The BC courts turned upside down and with a financial storm the idea of writing kids out of the will, supported in a principled way by the statute and by their expectations of moral behavior. The Supreme Court of Canada and Brassard said, look, in a murder-suicide case, it's the first time ever the Supreme Court of Canada awarded $10,000 to be paid from a murderer's estate as punitive damages, and that was in a murder-suicide case. It's not a sort of a logic tree that is foreign to us. It's just that the courts are starting to, with those kinds of winds blowing, send messages to us that we have to be cognizant of the fact that we are moving outside of the box in some respects. And as I mentioned, and I refer to my paper, David Friedman has written a great article in the Estates, Trusts, and Pensions Journal, which talks about unjust enrichment against an estate and those kinds of claims. And I want to talk a little bit about that because it is about protecting an estate and seeing where those claims are coming from. I don't think we should be waking up in Ontario with the view that testamentary freedom has completely been eliminated. And I think, and I wish, in some ways, on a cold day like this, I wish I was practicing in the middle of downtown Vancouver, but I don't. I don't know British Columbia law, but I get the sense that those guys are really loosening up the strings on testamentary freedom maybe on a fairly rapid basis. But what Friedman talks about is that given the rigid adherence to formalities, which is in the estates and wills practice, what can we do about morally reprehensible behavior? And it comes down to the idea that, again, you can't, well, he says you can't simply just say it's wrong. And I tie it to the old adage that you see and you hear about clients say far too often, is that this is what Daddy wanted, this is what I know he wanted. Of course, when you really press on it, it's maybe not have been said to him, the client, quite as clearly as you'd like. This is always what my dad wanted. Or the other classic is, one day this will all be yours. You get to that kind of expectations, and they're expectations that are created, and then as lawyers we come and layer on this, well, nice try. We have to prove it. Well, how do we prove it, and how are we going to prove it? In the unjust enrichment framework, you can prove it. And as long as it's within the principled approach, which David Friedman has so carefully articulated, and that's why I tend to refer to it, because he's just said it so well. He says, if you're going to approach these kinds of cases, which are really cases where as lawyers and as financial advisors and whatever our client is sitting across the table, I think it has elevated our expectations by the courts of what we're going to pull out of them in that client meeting. We're going to really look to beyond what are the conventional four corners of what we think this client could get out of this claim or defense of the claim. And it forces me to look at things like behavior, and maybe not written, but maybe supported by some good, solid, corroborative evidence. When someone says, Daddy said one day this will all be yours, instead of sort of rolling my eyes back saying, yeah, well, hey, daddies always say that, I think we are expected to really start to drill down on those claims. And if we can follow the facts in this principled approach, we are going to see success. And the Court of Appeal in Ontario, and I refer to it in my two papers, in my paper, there's two cases. They're embracing these kinds of approaches. This isn't just sort of pulling it out of a hat. The way I think we're best to pursue these as well is at the front line start to say to our clients, okay, well, what kind of expectations have you created? And, of course, our clients, and maybe it says, well, look, I've helped my kids out in university. They got through university, and, I might help them out from time to time. Really pushing their clients now on what are they doing on a go-forward basis with their adult children. And the cases in British Columbia and the Cummings case all talk about independent adult children making claims, not just, they're working for the bank, they got a great job. But when you drill down now with our clients and we say, well, wait a minute, now, just what does that mean from you? Are you still sending I don't know, are you paying for this? Are you sending a monthly check for this? What kind of assistance are you doing? Because when our client just says, oh, no, I'll give it all to so-and-so and it's all going to be fine, we're expected to go beyond that now. And we want to avoid criticism at the end of the day, but we also want to add that value and really highlight it. So what are the reasonable expectations? Friedman talks about there's sort of four parts. What are the reasonable expectations of the parties? Well, I've got to be better at pulling that out of my client at the interview stage. I have to look at the facts outside the box. The reasonable expectations based on the facts is how Friedman describes it. Then he says, in the context of developing principles of law, unjust enrichment is a developing principle of law, has been since the Supreme Court of Canada in the 70s, really started to embrace it with the classic constructive trust claims, where they took this concept of resulting trust, the concept of unjust enrichment and expanded it into the constructive trust world in a principled way. That is the developing principle of law. Well, it seems to me we have, not that we have to project it, but we have some pretty clear signs of developing principles of law, and that we have clear messages. So we look at the facts and we try to set it out, and then we say in the context of the appropriate public policy. So our goal is really just to look at these things, as Friedman says, in this kind of principled manner. And that allows me to sort of sit down with my clients and say, okay, well, really, who is my client here? And what is, do I have joint retainers here? Do I have a phantom client out here that is classic scenarios? Is that I bring a dependence relief claim for someone who looks like, yeah, we'll get a few bucks here and it's a good claim, but it's not, going to decimate the estate. And then all of a sudden I've created a phantom client in a sense because under the Act there's a sheltering provision, and then all of a sudden we've got a real dependent out there who's going to come swoop in and take 80% of that worth of that claim out of my knees, and all I've done is started a claim really from the phantom client. The questions like this allow us really to think again outside the box at that early stage. So what is the distinction here, and what are we getting at? It's beyond the old-fashioned kind of approach where in Degelman and the Supreme Court of Canada in the 50s said, you get paid for work and services. That's where the genesis of this whole idea of unjust enrichment, where we had the disappointed nephew who performed work and services based on a promise, didn't get paid, and the court found a way to pay. And what they're doing, in my view, is the courts are finding ways to pay if the facts are there and supported. And as I say, I think the best way we can do it is keep it in this principled approach. So we speak of the remedies arising out of a valid contract. What contract, what expectations have been created? And from an estate planning standpoint, it seems to me that for my role is it's fundamental for me to understand what valid contracts have been created. It's not just the car lease for my 93-year-old aunt and knowing that car lease may survive her, and understanding that contract is going to be an obligation that I have to deal with on her death. It's beyond that, and it's at that stage of the intake that we really have to. I'm really having to rethink how I'm managing these new frontiers. These frontiers of quantum merit were established in the 50s. Now we've got things like moral obligation. We've got things like proprietary estoppel. Proprietary estoppel is deeply entrenched in the UK, in the UK law. There's not, in all the publications, the cases that come out, there's not a month that goes by that they haven't got a new proprietary estoppel case out there. There's punitive and exemplary damages that are starting to creep in. This is the developing areas. Now, again, what does that, how we tie that in with our clients in the context of unjust enrichment is that I need to look for the benefit or the enrichment of one party. I have to go to the corresponding detriment. What did it cost me? And I have to look for this absence of juristic reason. Is this just a dumb idea to get damages for this person? Does it make any sense to us? And so I just want to spend a few minutes on is the idea that really it seems to me that the principled approach is founded on and if you had to sort of summarize some of the innovative trends is that the concept of testamentary freedom is subject to one's obligations. And that comes down to my role then as to what are those obligations, and are those obligations beyond those that would we conventionally consider. So when I press my clients and I start to take some intake while they're live and at the pre-death stage, I want to start to really press them on what have you done, what have you said. And I'm not sure that, and I've added it to our checklist. I mean, what have you told your kids you're going to do? Or what have you told anyone? What have you told your caregiver you're going to give them? And sometimes the client's embarrassed, sometimes they won't tell you. I think as an aside, I think just from a protection mode, I would like to think that I have a little note of that question just because I've canvassed what are knowing growth claims, and that is claims from these sort of tangent aspects of one's life. And it's easy to do. Just add your checklist, what promises have you made, and then press on it a little bit if you start to get some information. Proprietary estoppel is the one area where I'm not sure, again, as I say, I'll speak about the two Ontario Court of Appeal cases that are embracing it, and the 2010 decision that I have in my paper, the Schwark decision, absolutely embraces it. But the proprietary estoppel is the same thing. If we have a case where there is enrichment in the hands of someone else, all right, and so the estate falls in, and one of the leading cases talks about the gardener who was promised the house, and the estate falls in, goes to the great-nephew. The great-nephew says, great, I'm happy, I'm really, this is my, I won the lottery, I didn't really like my aunt that much anyway, and I'm happy to take her money. And then the gardener would come knocking on my door and says, well, what do I do? She said that, that one day this was all going to be yours. And so we have the enrichment in the hands of the nephew. We have the corresponding deprivation because the poor gardener had worked for 15 years every week doing what he's supposed to do for her, keeping this beautiful English garden, and for nothing. And then they looked for the juristic reason not to. Is there any good reason? This is morally reprehensible. The court sort of said, no, this is morally reprehensible. What do? We go to the Court of Equity. How does the Court of Equity handle this? Well, it's not just a magic wand. We need some good corroborative evidence. We need some, meat on the bone here. Give us something. Show me where the promise was made or the expectation was created. And in Ontario, we've got a pretty rigid, and although it's, I don't think it's more rigid than the British approach to corroborative evidence. But again, I don't practice in downtown London, England. But the statute is pretty clear. We need strong corroborative evidence. There's a Court of Appeal case that talks about, it's a case of Dunn Estate, where it talks about the will was corroborative evidence for the proprietary estoppel. That was sufficient evidence to show that the promise was made. It was you might have a precatory comment saying, thanks, I've thought about the gardener, thanks for all his help. And in that case, the Dunn case, they used the provisions of the will actually to flip it around. But the point was that the courts will look pretty far and wide for the corroborative evidence. And so when the client just says, well, they said it, and I say, well, did anyone hear you say it? And they say no. I push further on that. And it's even better to be able to ask that question of your client, who is, you press them and say, well, you've got a gardener coming once a week, and you told me that you rely on that heavily and you love your garden and you thank the gardener for doing this, and those kinds of scenarios, and then I can draw out to say, well, what kind of expectations does the gardener have? And I don't think my clients don't typically get offended by this, and I will, and I keep pressing back on them to say, look, the truth is that these kind of irrevocable, that we call in the case law, I talked about it, they're irrevocable testamentary promises. So do we have any irrevocable testamentary promises? Have you done and gone, given something away before without you knowing it? And that is where testamentary freedom, I think certainly in Ontario, can get cut down at the knees, even at the high level that they did in British Columbia. They went at it at a different approach, but the same thing happens here. So if you get those promises, you can find that the basis of it is really the imposition of the equity of the situation. And so the last comment I just want to make is, as I say, this is not out of thin air in Ontario. The Depew case and the Wilkes case I talk about in my paper, and the Schwark decision that's in our probator, the May 2010 article that Susanna Popovic-Montag wrote, talk about how the Court of Appeal have, A, embraced proprietary estoppel. It's an innovative claim, sure, but the concept is absolutely confirmed by the Court of Appeal. And then in the Swart case, they actually went into a good, helpful analysis to what they're going to expect in the Ontario context as to what's needed for that kind of unjust enrichment claim. So we do have a window here, it seems to me, that where there is morally reprehensible behavior and promises and expectations created, that the court has an avenue, and they can't simply just give us short shrift of it when by saying, well, we don't have a Wills Variation Act. Well, we actually do. We have a concept called unjust enrichment, which has been a long time around, a lot longer than the Wills Variation Act has, and we have foundation for it. So I step back and look at this, and I really do hope that I'm pulling out of my client the why. What are we really doing here? Why are we pursuing this claim? And it can't be, well, it can be at the end of the day, but it usually is not just about the sand being kicked in the sandbox when they were 4 years old at each other. It is more about expectations that were legitimately created by someone who has now passed away. And now we can take that chance to explore them and to sort of pursue them in a very principled and meaningful way to hopefully achieve a successful claim, or to turn it around on it when we're defending these unjust enrichment claims with the strength and the power of Section 13 of the Evidence Act, which is going to require significant and corroborative evidence. So promise me all this, those promises and the expectations that are sometimes manufactured by our clients or by individuals can be properly defended. So those are my comments in regard to the approach of unjust enrichment and some of the innovations that are going on in the courts, and how we can look forward to keeping the public policy framework in our mind as we continue to take our clients' instructions or assist them in their financial planning, because that's what's out there, and it seems to me to bring some context to it. So thank you all for coming to this breakfast on this cold January morning. We will stick around for, it's 9:30. We'd like to have people get back to their office if they so choose, but we have some microphones set up. We can stick around for some questions. Formally and or informally, we're happy to be approached after it. So again, thank you to our speakers today, and welcome everyone to 2011, and have a good year. Thank you.
I have a question for Rick on guardianship. If there's a continuing and valid power of attorney for personal care and property, is there any reason why someone would apply for guardianship unless they want to knock out someone else's power of attorney?
Yeah, there is, and that may be an option. Another option may be that that person who was appointed as the attorney no longer wishes to act under the power of attorney. So he wants to resign, and somebody else has to be appointed because that person is now incapable, and he's unable to voluntarily sign a new power of attorney. And again, there's a body of case law on not reasons why a guardian would be appointed, but on when it's appropriate to appoint a guardian in light of a power of attorney being in place.
You know, there's an important, just to add to that, there's an important distinction. And when you have a valid power of attorney and you can act on it, you do not have to have a finding of incapacity. You can, by bringing an application for guardianship in the right circumstances, it actually, for a family, it might be a beneficial thing, even though you have a valid power of attorney, because you can get a declaration of incapacity. And it allows you a different approach. I mean, essentially, it's a more blanketed approach to the controlling the individual's behavior. Someone in the gray area who is out spending their money, the banks aren't really in a position to stop the individual. Maybe they're using ATMs or whatever, and every day they're burning, $500, and we're not sure where it's going, or loans are being given to friends at bars that they hang out with, or something like that. By bringing the guardianship application in the face of a power of attorney, you allow yourself that extra blanketed authority to say to the bank, well, actually, we have a finding of incapacity, and notwithstanding the fact that my power of attorney governs, it doesn't preclude activity on part of my mother. So I'm now telling you, bank, with this court order, you cannot deal with my mother anymore. So that's another reason where you might consider it. And it's unfortunately, it's coming up more and more. They're hard cases because these people are typically in that, what I consider the gray area, and but they're important considerations, and one that I offered up to the family to consider, although it is a terrible thing to have to say, but you're going to find someone incapable, but it's because of the debilitation of their rights, it's something that maybe is the right thing to do.
And I've also seen a wealth of case law on the fact that the person appointed under the attorney is a rogue attorney, in the sense that he's misappropriating the funds of the incapable person. And in that situation, a guardian may likely be appointed if it can be properly demonstrated to a court that the attorney is not the best character to be making decisions for the incapable person.
Hi, Ian.
Hi there. Actually, this is a question for Craig, and a comment I always enjoy hearing about the latest cases, the Vidicek case about the joint accounts, because I think we're all asked about joint accounts here and there. So I took that to mean on the joint, part of the rationale for the judge finding that the joint account was part of the estate was because it's a common thing to avoid probate. But then if by the judge so finding that, assuming that there's some other asset, let's say in the hands of the testator solely that they need to get probate for, presumably then that joint account will then have to be included on the affidavit and listed and probate tax paid on.
Well, in this particular case, yeah, that would have been the consequence, that the joint account would have fallen back into the estate because it's in a trust situation. I mean, to piggyback on your comment, what's interesting about the GIC aspect of this is that that's also a liquid asset. There may be a penalty, perhaps, for cashing it in, but presumably you could cash the GIC in and it becomes cash, and you could deal with the payment of debts with it. So it was interesting, I thought, to see the judge make a distinction between a joint bank account, because it is thought of as being a device or a vehicle through which you can assist mom or dad with the administration. They're capable, but they don't want to go down to the bank, they don't want to pay their bills, so one of the kids helps out. And the fact that that wasn't going to lend itself to being a joint asset, whereas the GIC was. Yeah. And my understanding of the case is that all three kids really weren't at odds with each other over that, which makes it more interesting too.
Yeah, and one was joint on the account, and the other two were joint on the GICs in different results. So there's various accounts. I guess my comment is only that maybe we'll have to asset by asset make declarations and maybe multiple wills, so that if the resulting trust is found or assumed, that at least you don't get hit with the probate tax.
I certainly think acknowledging that there could be and finding out and having declarations with respect to these different types of assets is a way to approach it, given that decision anyways.
Yeah, in fact, there's a great precedent that's out on the internet. I think it's called jointassets.com. It's out there, and I saw the form, and just thought it was an interesting form because it particularizes the asset. It says, my joint account, asset, account number, blah, blah, blah. And so I think it really is important to have these declarations, because a global expectation is, it isn't, I don't even think that's what Pecori told us either. I think they really did say, tell us what you mean, particularly with regard to each and every asset, in that sense that we need some clarity as to what you guys want to do with joint accounts. So, I think the decision is correct. I think it's consistent, and it's absolutely right. We have to encourage our clients to, delineate exactly what is each asset. Hi, Wendy.
Good morning. I don't know if this is working. Can you speak louder?
We can hear you.
It's a gray area that I wanted to delve into and maybe ask Rick. Increasingly, we're dealing with people who have graduated rates of capacity. And one of the interesting things that I see is where a person may not be capable of managing their own affairs, but they might be capable of granting a power of attorney. And where are you with a guardianship order in that instance? And obviously getting the individual to grant a power of attorney or a new power of attorney if there's problems with the persons who are appointed under one that was granted a long time ago. would be the path of least resistance. But do you have any comments, or is there any case law on kind of, where a person might be capable of doing some things and not others, and where the courts have adjudicated on what's appropriate for parties and family members, and what kind of advice you give in those circumstances?
See, at the end of the day, it all turns to corroborating evidence, right? And a court, the judge who is going to make a decision, they're not doctors, they're judges. So they will only look at the opinion evidence that's provided to them. And in that opinion evidence, all we can do is get the records of assessors or doctors that back up the request for a declaration that this person is incapable. And in that situation where there is enough evidence, the court will grant it. But I hear what you're saying. You're saying there's a gray area where there's some days there's good days, and there's some days there's bad days. Okay. And all you can do in that situation...
You may not even get consent for an assessment, for example. I mean, that's one problem that I see, where you might think of doing a guardianship order, but if you're going to do it the regular route and you need consent, and maybe the family doesn't even want to put the individual through that.
In that situation, I would just, if it was me, I would apply to the court seeking an order that that person be subject to a capacity assessment. And of course, it's going to be contested, but that's where the lawyerness comes out. That's where we have to build in our supporting affidavit the rationale for seeking that order, which is that the allegedly incapable person should be subject to a capacity assessment.
So if you can't get an incapacity assessment, can you just grant a new power of attorney?
Well, I mean, the problem is, it's a good question, because the act, the umbrella over the act is what's in the best interest of the alleged incapable. So what, and the courts have discretion as wide as this room as to how to make that happen. So when you could go to the court and deal with the layering and say, you know what, we just want a capacity assessment to be undertaken pursuant to Section 79, and the courts have said you cannot do this without bringing a guardianship application. When it first came out, we used to go right for the Section 79 orders and say, well, we got a good reason to get them assessed. Once that's determined, then we'll decide if there's going to be a guardianship. The court said we can't do that. You have to step into the fray, bring your guardianship application. So you bring your guardianship application and you fine-tune the relief you're seeking, and that is a capacity assessment in respect of whether or not they're capable of making a power of attorney, not that they're incapable of managing their affairs. And so if we fine-tune the relief we're seeking, which we're entitled to do for sure, it's in the best interest of the incapable, then the court is going to be much more comfortable making that kind of order, instead of declaring them completely incapable, so to speak, and that allows us to play with this gray area a little bit. And there's lots of authority for the proposition, Justice Brown and the Chu decision, and lots. I mean, I can think of is that where the courts keep coming back to, well, they've asked us a very difficult question, and I've answered it on the best because I have determined what's in the best interest of the incapable.
But if you're applying for guardianship and you're only asking for an order that they're incapable of making the power of attorney, then that doesn't give you a guardianship order. That seems...
Well, I mean, it gives you well, I mean, I guess it gives you a parameters of an order, though. I mean, it gives you some control. You're right. You're absolutely right. They're just not going to give the blanket incapacity finding where there's a gray area. They don't repeatedly, and they shouldn't. And because these judges are going to be, someone's going to make them count backwards from 100 one day too, and they're not going to give this job up easy. So, and some of them are getting older, and some are getting not so older, and so they're all very cognizant of that. So I hear you. But that's where I think that we have to. It's back to my innovative, but it's flexible. The act was flexible in '94. I'm not sure. I think when we jumped into it, we sort of just tried to follow the statute. The cases have pushed us away from that and said, let's not get so stuck on the technicalities here. Let's start talking about what's in the best interest, and let's design our management plan, our assessment. I did one that I actually said these are the questions that that the assessor only has to be comfortable that this person can understand, because they only had 3 assets, and what they were doing with it. So you can really fine-tune this stuff. And that comes back to the intake, right? You sit down with your client who's potentially the guardian and say, okay, but just exactly what are you doing here? And it's not, the why. What do we really want to achieve? Why are we going to this length? Is this person behaving in a way that's worrisome financially? Or are you just being a nice person? Or like looking at the motivations can help us refine it. And then I just sit there, and I don't like precedents with that stuff. I say, let's think outside the box. What is the best for this individual? Because this individual's level of capacity is here, and the last time we did it, they were here, and now this one's going to be here. And where they are cognitively and their behavior is where we should be coming to the court from. And if you do it quick enough, it's current. But if we do it too slow, then it's irrelevant, because dementia can be something that is a moving target.
Also, too, there's, and really what I think Ian is in part getting at, too, is there's layering of relief that you're asking for in your notice of application. You might be asking, ultimately, that they be declared incapable, but you're also asking in the alternative, the specific relief that Ian was just mentioning about, do they have the capacity to execute a power of attorney and make a power of attorney. And then you make it clear when you're going to court that it's only that aspect that you're initially interpreted in, or you're initially pursuing, and that way that, frankly, the judge isn't getting on his or her heels about being confronted with the whole process. Because really what you're doing is you're breaking it down, but you might be putting in relief to meet the requirements of the Act in terms of what you need in your application. So I think, it's exactly what Ian is saying. It's being flexible and thinking about, do I layer my relief? And maybe I have to go back to court 3 times. Maybe I'm not going to be doing this all, with a view that we bring the application, we're going to go there. Maybe it is quite a layered step process. And that's where thinking outside the box really comes into play.
Thank you.
Thanks, Wendy.
In relation to guardian for infant children, clauses in a will, or can you also do it by a separate document without going to get it court ordered?
Well,
Many wills contain a provision.
yes. It's best under the will, for sure, and as you right, Sid, that from that perspective, and under the Children's Law Reform Act, anything over $10,000 is subject to a guardianship order for a child if it's not dealt with in the will. Those are really, and then in that case, you have to apply for a guardianship order pursuant to the Children's Law Reform Act, which is, and in and of itself, pretty well similar to the guardianship of a person. The Act doesn't set out the parameters like the Subsidy Decisions Act, but it gives you the same framework. The Children's Lawyer's Office expects a management plan. What are you going to do with this $100,000 that wasn't properly dealt with in the will? Say it's a gift of $100,000 outright to a minor or something like that. What is your plan as guardian with that? So you set out a management plan. Those are really the only ways that you can effectively deal with it, or, of course, under the will, put it properly in a trust and appoint a trustee and manage it. Yeah.
The guardian is separate from the executor.
Yeah, and you can, and that's right. That's for sure. But those are really, that's when it comes right down to it. There's not a lot of flexibility. It's so important at the drafting stage to pick those gifts up properly.
Yeah, and I think the CLRA also limits you if you're going to build it into the will. There's a timeline as when you need to apply for a guardianship. 90 days.
No, but that's guardianship for custody.
Yeah.
Custody is a 90-day appointment. This is guardianship for financial, and there's no timeline for that. Thanks, Sid. All right, we have one more question, and then we'll let everyone go earn a living.
In terms of the definition of finding somebody incapable of managing property, it's obviously very wide, the wording. As provided in the paper, it says person is incapable if the person is not able to understand information that is relevant to making a decision in the management of his or her property. I'm thinking, my gosh, almost everybody would fall under that.
Certainly fits into my investment portfolio.
I'm thinking of Nortel.
Yeah.
My gosh, where everybody,
Yeah.
many people to that. So I'm wondering, is there anything else more limited in its definition, and if not, what will be the case?
There is no more. The definition is purposely wide in that way, and good question on what is the leading case. There really is a variety of. I'm hesitant only because it's the better question for me in my mind is what's the more current leading case, because it seems to be moving a little bit of a target. But the courts have definitely just approached that on a fact-by-fact basis, and they haven't really, I don't think, aggressively. They certainly haven't aggressively restricted it. They, in fact, aggressively expanded it. It started way back in '94 when Justice Quinn took the Koch decision and said, this is akin to putting someone in jail. We're going to really investigate whether or not they're capable or incapable, and I want to see really fulsome evidence. But as Rick says, it comes down to the evidence before you, the medical opinions, that kind of parameters. That will be what restricts you, not the language, and no judge will have the, and nor they should, have the ignore the broad expansiveness of the language, because there's a presumption of capacity. So.
Yeah, Koch is a commonly referred to case dealing with incapables. I don't have the citation in my paper, but I do have my email address, so if you send me an email, I'll definitely shoot you back the citation for that case.
It's KOCH. It's, I think, 1994. Justice Quinn, down in the Niagara Peninsula, gave his words of wisdom on that. And it started the ball rolling in terms of what the court should do. So on that note, why don't we get our scarves back on and start walking back to our place. Thank you so much for everyone for showing up today on this beautiful but